Hi, it's Bernard Nomberg with the Nomberg Law Firm in Birmingham, Alabama. And one thing that comes up in our cases from time to time is the length of time from when an accident or event occurs until the client, the injured worker, the plaintiff, goes and seeks medical care. Every case, every fact scenario is different. However, there are some general rules of thought that really ought to be considered in these situations. When somebody gets hurt in an accident, sometimes it's an accident where they just slip and fall and they're embarrassed and they don't want to go and tell somebody about it. Or there are other accidents that are truly something that they had nothing to in control and they're very serious and they need immediate medical care. Some injuries don't show up for days, weeks, or months. Those are called latent injuries. While every situation is different, if you've been injured in any type of an event, whether you slip and fall at work or a car accident, or you had something that occurred while at work that needs immediate attention. If you have any type of injury whatsoever, first of all, you need to report it if you can to your supervisor if it's a work-related incident. Either to your supervisor, human resources, whatever your company's protocol, policies, procedures call for, you need to follow that. If your injuries are acute, meaning they're very severe at the time and you can't, hopefully somebody at your employment is helping you there and they can report it. But then the next event is, when do you go seek medical care? Well, it needs to be documented as soon as possible, even if it's something that's pretty minor. You need to be able to explain to the medical doctor, so it can be put in the notes, what you're feeling and what's going on with you from a pain standpoint, from an injury standpoint. Documentation really is the key. You don't want to go 6 months and 9 months or however long out and not have any medical care, not get checked out whatsoever, because that raises a little bit of doubt as to when and where the event causing the causing the injuries may have occurred. I'll give you an example. Person has a slip and fall accident where they fall on a roof in ice and they do have some injuries to one part of their body, but don't seek medical care for another part of their body that may have been injured from that event. 6 months go by until there's other medical care given for the initial injuries, and that's at that point, at the 6-month part, you haven't had any medical care for another part of your body, say your low back, until the 6-month part. Well, that raises some doubts in the medical professionals' minds, and if you're pursuing a case, in the adjuster's minds, maybe the judge or a jury, that whether that low back injury may or may not have occurred 6 months prior when you slipped and fell on the roof. And the reason why I bring that example up is, if you have any idea of what body parts may be bothering you and when the symptoms began, you need to document it. You need to have medical medical professionals take a look at it, and you need to, whether it's minor or something that's of significance. The point here being, and the purpose of this video, is to demonstrate, regardless of the type of event, whether it's at work or not at work, a car accident or personal injury case, any and all medical issues need to be documented as soon as possible. If you have any questions or concerns about this, just give us a call. 205-930-6900 is our office number. Nomberglaw.com is our website. If you like this video, please consider giving us a thumbs up and subscribing, as we put out new videos every week. If you didn't care for this video, tell us that too, and give us a thumbs down or tell us what you thought about it. We also want to hear from you. We can additionally be found on Twitter, Instagram, and Facebook.